Hello, and welcome back to Business Law Online. Um, I'm going to be finishing up torts with this lecture. Hopefully it won't be too long. When we last left off, we were talking about primarily torts, uh, intentional torts to persons. Now, intentional torts tend to be right-based. In other words, you have a right not to be touched in a harmful or an offensive manner. That would be covered by assault and battery. You have a right to move around freely. That would be covered, and if someone violates that, that would be the tort of false imprisonment. You have a right not to have people tell untrue statements about you, or to cast you in a false light. And if someone does those things, that would be covered by the torts of invasion of privacy and defamation. Well, I'm going to continue along that same vein with respect to torts to businesses. Now, as you also notice with those intentional torts to persons, not all of them are related to personal injury. With respect to the right to privacy, that's injury to your right to be left alone. With respect to defamation, that's your right not to have someone say something untrue about you. Um, and business torts are kind of the same way. They kind of cover the rights of your businesses to be dealt with fairly, for lack of a better word. Now, the first business tort I want to cover is unfair competition. Now, unfair competition is a very broad tort. There are all kinds of different versions of it. I'm going to cover two, palming off and unfair business tactics. Now, unfair competition is actually a lot like trademark infringement, which we'll cover later on during the semester when we cover uh, intellectual property. Excuse me, I'm just adjusting the camera. So, unfair competition. The first type is palming off. Now, palming off is basically where one party is trying to convince consumers that its goods are the same as the plaintiff's goods. In fact, they are the plaintiff's goods. So this kind of sounds like counterfeiting. It kind of sounds like knockoffs. It's somewhere in between those two. Now, for a plaintiff to establish a successful palming off unfair competition lawsuit, the camera keeps on falling, I'm sorry. They have to establish two things. Number one, the defendant used the plaintiff's logo or slogan, some kind of design, some kind of artwork that is closely associated with the plaintiff. In fact, the plaintiff actually owns, either by copyright or trademark or even patent. Two, that as a result of using this, as a result of using the plaintiff's trademark, logo, slogan, artwork of some kind, that consumers are likely to be confused as to the source of the goods. So those are the two elements. Now, the interesting thing is that actual consumer confusion is not required. The plaintiff does not have to prove actual consumer confusion, just that the goods are so similar, it's highly likely. That's all they have to do. That's all they have to do. So that's palming off. The other type of unfair competition, which is really important, I guess you can call it unfair business tactics or aggressive business tactics. Sorry, my camera keeps on falling. I'm trying to keep it up a little bit. What would that include? Well, there's an interesting case out of Kentucky. It involves Domino's Pizza, Papa John's, and the University of Kentucky. This is back in 1998, but it's an old case, but it's good because it really demonstrates how broad unfair competition can be. In that case, Papa John's had entered into an agreement with the University of Kentucky, wherein University of Kentucky students could use their meal card at the local Papa John's franchise. Now, if you were Papa John's, you are ecstatic. University of Kentucky has got tens of thousands of students. They all live on campus, and they all have meal cards. All of a sudden, they can use their meal cards at your restaurant. Obviously, this is going to be a big boon to your business. The flip side of that, though, is that the Domino's franchise that basically serviced the University of Kentucky, now all of a sudden what? They're at a real strategic disadvantage vis-a-vis Papa John's. So that franchisee, that Domino's franchisee, sued the University of Kentucky and Papa John's. Why? Based on unfair competition. The Domino's franchisee sued for an injunction. Now, an injunction is basically a court order telling parties to stop, right? In this case, stop the contract. The injunction was granted. So you could see how unfair competition is a really broad tort. I'm not even sure what Papa John's or University of Kentucky did that was wrong reading the case. But in any event, Domino's Pizza prevailed. They got an injunction. So that's two types of unfair competition. Now, another important business tort is false advertising. And there are basically two types of false advertising. One is literal falsity. The other is consumer confusion. So it's kind of similar in a sense to unfair competition, but it's related to a party's advertising efforts. Now, there are two interesting cases to demonstrate both. Now, false advertising is covered under federal law by the Lanham Act, Lanham, Section 43A. Now, literal falsity is about the allegation that the defendant is alleging that the defendant has made an untrue scientific statement about your products. Now, a great case to demonstrate that involves Ziploc and Gladlock bags. Ziploc bags are manufactured by S.C. Johnson. Gladlock bags are manufactured by the Clorox Company, two very different companies. Now, a while ago, perhaps you remember this, there was a commercial wherein it was a Gladlock commercial, wherein there was, I think, an actress, and she was standing in front of a table, and on this table were two bags, one a Ziploc bag and the other a Gladlock bag. Now, the bags were filled with water, and in each bag there was what? A goldfish. So the actress or actor, to demonstrate how that Gladlock bags were better than Ziploc bags, picked up both bags and turned them upside down. Now, the Gladlock bag stayed completely sealed. And of course, the goldfish in that bag was what? Had a big smile on his face. Why? Because he knew he was safe. He was in a Gladlock bag and it wouldn't leak water and he wouldn't die. Of course, the Ziploc bag was leaking like crazy, and the goldfish in there had a very concerned look on his face that, oh my God, this bag is soon going to run out of water. What's going to happen to me? Well, Ziploc, S.C. Johnson, didn't like that commercial. So they performed their own test following what was done in that commercial. And based upon their own testing, they concluded literal falsity. So they sued the Clorox Company, and they performed these tests in court, and they showed the results. And what did it show? The results from S.C. Johnson Ziploc showed that, number one, Ziploc bags didn't leak with any more greater frequency than Gladlock bags. And number two, to the extent that Ziploc bags leaked at all, they certainly did not leak as much as was portrayed in the commercial. Ziploc, S.C. Johnson prevailed. So that's a good case demonstrating literal falsity. It's basically scientific falsity. Now, the next type of false advertising that's really important and you've got to know is the likelihood of consumer confusion. Now, again, this is also covered by the Lanham Act, Section 43A. And there's an interesting case there that demonstrates it. Pizza Hut versus Papa John's. Now, this case was tried, I believe, in Missouri. And as you know, Papa John's, one of their slogans is better ingredients, better pizza. Pizza Hut sued, alleging likelihood of consumer confusion uh, as to, or not just consumer confusion, but that consumers would be misled, confused and misled. Now, the court went over each element of, of this type of false advertising, where consumers would be misled and confused. One, there is a false or misleading statement of fact about a product. Now here, better ingredients, better pizza. What about that? Is that a fact or is that an opinion? Well, the court believed that that was a fact. So better ingredients, better pizza was fine. But also in that commercial, Papa John's made certain assertions. One, Papa John's pizzas were topped with vine-ripened tomatoes. Pizza Hut pizza, well, that was topped with reconstituted tomato paste. Which one sounds better? Which one would you want? Vine-ripened tomatoes or reconstituted tomato paste? Two, Papa John's pizza, well, that was made using filtered water. The implication? All the other pizzas are made using filthy water. So filtered clean water versus filthy water, infected with E. coli and the like. There the court said, hold on, that's a statement of fact. Now you're making a statement of fact. You're moving beyond opinion to fact. So that was number one. Two, the statement either deceived or had the capacity to deceive a substantial segment of the consumer population. Here is actually an interesting case. It starts to get interesting with this case. The court was really concerned about this element and the third element. The deception is material. That is, it's likely to influence consumer purchasing decisions. So one, it has to have the capacity to deceive, and two, it's going to influence consumer decisions. Here's where Pizza Hut had a problem. They failed to produce any evidence establishing that. What kind of evidence would they need? Consumer surveys, and they failed to do that. They failed to do that. So the case, although Pizza Hut won at trial on appeal based on those two elements, the case was reversed. The other elements for false advertising is the product is in interstate commerce because it is a federal statute. Federal statutes can only regulate goods that are in interstate commerce. And three, the plaintiff has been or will likely be injured as a result. But that whole idea of misleading consumers, it's tough. If you're going to make that type of allegation for false advertising, you've got to have proof. You've got to have consumer surveys. It's not enough that they simply made a statement of fact. You also have to show that that statement of fact was material and it affected consumers' purchasing decisions. All right, so those are the two types of false advertising. There's another important business tort, and it's kind of related to misleading consumers. It's kind of related to defamation, and that's called disparagement. Now, disparagement is basically defamation for businesses. With disparagement, the plaintiff is alleging that the defendant made an untrue statement about the plaintiff's products, services, property, or business reputation. The elements are as follows. One, the plaintiff has to establish the defendant made an untrue statement, exactly like defamation. Two, the plaintiff has to establish that the defendant published it, in other words, told somebody or wrote it somewhere where other people can read it. So far, it's exactly the same as defamation. Three, the defendant knew the statement was untrue. And four, the defendant did so maliciously. In other words, they wanted to hurt the plaintiff. So it's very similar to defamation, and it is also another powerful business tort. All right. I want to go now and discuss negligence. I want to try and keep this lecture short. Now, negligence torts are really duty-based torts. And what I mean by that is that each one of us, we owe each other a duty to act with reasonable care under the circumstances. The duty to act with the type of care that a reasonable person would under similar circumstances. Now, basically, it's an accident that really, with a little bit of care, could have been avoided. So it's a duties-based sort of tort. Now, with negligence, the defendant may have intended the act, but they did not intend what? The consequences. But the key is they should have intended the consequences. The reasonable person under similar circumstances would have intended the consequences, and they would have acted differently. That's what negligence is about. It really is looking back at the defendant's behavior. Now, there are 4 elements to any negligence claim, and they're all interrelated. They all connect to one another. Number 1, there's a duty of care. It's not enough that you were injured as a result of some kind of accident. You have to prove that the person who caused that accident violated their duty of care under the circumstances. In other words, they had a legal obligation to conform to a standard of care that would protect others in the same circumstances. So, duty of care. Duty of care, what are some factors that courts look at in establishing whether or not there was a duty of care? Well, number 1, and this is a big one, was the defendant on actual notice? That is, do they actually know of a dangerous condition and that they caused? Or were they on constructive notice? That is, maybe they didn't know of the dangerous condition that they caused, but it existed for a long enough time that a reasonable person would have known about that condition. So number 1, one factor that courts look at in determining whether or not there was a duty of care, either actual or constructive notice, was the defendant on actual or constructive notice of the condition. Okay. 2, the risk versus the cost of avoiding the risk. If the risks are great and the cost of avoiding it are small, the court is more likely to determine, in fact, there was a duty. A great example of this is diagnostic testing. Obviously a big women's health issue. The Susan G. Komen Foundation, is a big advocate for this, is breast cancer. Now, breast cancer, there's a lot of research into it. And one of the things that the research has proved is what? Early detection greatly increases, 1, your chances of survival, and 2, quite frankly, the treatment is a lot less expensive. But early detection is based on what? Going for diagnostic testing, going for the mammograms and the like. Going for a mammogram is not going to prevent breast cancer, but what it does is if you can detect it earlier rather than later, again, it greatly increases your chances of survival, and it also increases your chances, or it also reduces the cost. So why is it doctors are always saying, sending you for diagnostic tests? Well, diagnostic tests are really, relatively speaking, cheap. Cheap compared to the cost and the likelihood of success of treatment that would follow. So there, the risk, late-term detection of breast cancer versus the cost, relatively inexpensive diagnostic testing, makes a big difference. In that case, that's why most doctors will send their patients for diagnostic testing. It's a criticism of the medical industry, but I think it makes sense. It's cheap. It really is in the long run cheaper. To detect problems sooner rather than later. and also better rate of survival. Um, all right, so far we have actual versus constructive, and risk versus cost. Another factor that courts look at is whether or not the defendant's actions were active or passive. If the defendant was actually doing something, they're more likely to conclude that they violated a duty. If it's passive, they're more likely to conclude they didn't violate a duty. Why? Because the law does not want to require you to do something for the most part. The law really is very hesitant about taking that step. It's one thing if you're doing something, then yes, the law will say you have to do it according to this standard of care. But if you're not doing something, they don't want to force you to do something. That's a big theme in Western law and the common law. We're not going to force someone to do something. A very controversial case was out of Massachusetts, circa 1928. Osterland. Osterland was one of the parties, and in that case, the defendant basically watched the deceased drown in a lake. The deceased estate sued the individual, saying that they should have gone out and rescued him. It was established actually that the defendant was a pretty good swimmer, that he probably could have rescued the deceased without much risk to himself. But the court in that case was very hesitant to require the defendant to do that. Courts are very hesitant to turn a moral obligation into a legal obligation. So, and that case sparked a lot of outrage when it came out. This is 1928. We're not going to rescue people. You don't have to rescue people, even though very little chance of injuring yourself. Yeah, the court said no. We're not going to. If someone is not doing something, we're not going to put a duty on them to do something.